Well, hey there, everybody. I am just checking in from the beautiful, scenic town of Puerto Montt, Chile, where it is a very comfortable 68 degrees and lovely summer day here. I just wanted to take a minute to share with you guys a little bit of what's going on here. This is a port city, so it's a little bit, I'd say it reminds me of like Pioneer Square in Seattle a little bit. It's definitely got life and energy, but it's also got a little bit of seedy sides, some porteños that hang around. So very fun town. I do enjoy it. But one thing they have here is this lovely waterfront that I've been walking on. You can see it just goes on for a couple of miles. It's full of parks and families and stuff like that come down here. Chile is an incredibly family-friendly place. I mean, you can't hardly go like a couple blocks without running into a park and stuff like that. There's always lots of kids out, playing and doing kid things, having a good old time. So you probably will get some background noise while I make this video, but I wanted to check in while I've got signal out here because I finally took a look at that Richard Allen motion. I've read a lot about it and I'd seen bits and pieces from the affidavits and so forth, but I hadn't had a chance to sit down and read the whole 24 pages plus exhibits for myself. So I did that and thought I'd take the opportunity to fill you guys in a little bit on what was going on with that. Just kind of what I think about it and stuff. So if you haven't read the motion itself, it's a motion to correct error. It's essentially a motion that's made within a certain amount of time after sentencing. And I would say for practical purposes, what it's doing is it's preserving certain issues to be able to raise them on appeal. The issue with appeal, you've probably heard me talk about this before on the channel, is that you're limited to the record of what happened in the trial court because it's not really a process that's about, whether they got the right result or whether you're innocent or anything like that. It's about whether the trial court committed an error. And so you're looking at the rulings that the trial court made, the record of the information that it had, the legal arguments that were presented to it, and so forth. And so typically, if stuff isn't in the record or argument wasn't made and stuff like that on direct appeal, it's typically waived. And so if you get to raise that issue at all, it's usually going to be in the context of some other type of post-conviction proceeding. I just realized you're probably staring right at the sun in all of this. Oh well. So essentially what this motion is doing is it's raising these issues so that the appellate attorneys are going to have an opportunity to be able to argue them because, well, let's be real, we already know Judge Gull is not going to say there's any problem here. She may not deal with it at all. It looks like the motion is like she's got certain options of what to do with it. She can set a hearing on it. She can do nothing with it. She can call for a hearing on it, or she can deny it. If she doesn't act within a certain length of time, I think it's 45 days, then it's just deemed to be denied. And so that's kind of the path of least resistance here. The easy option that she could take is just let it sit on her desk. Then she doesn't have to do anything, and there's no record of any decision making that she engaged in that can be reviewed and looked at for error. So, don't know what's going to happen with it. We'll obviously just have to wait and see. But that's kind of the posturing of it. And it's with that posturing in mind, of course, being an appellate attorney myself, I do definitely have some thoughts and reactions to the motion and to the arguments that have been raised. And unfortunately, it's going to veer into one of the just less fun parts of appellate work sometimes, because your priority, of course, is the client, getting relief for the client. And sometimes you have to make arguments that aren't really that enjoyable to make, but you do them because it's in the client's best interest. So we'll get into that. So let's go through what they're actually arguing in this motion, just kind of a bit of an overview. They got 4 separate issues that they're arguing justify a new trial. So the first one is they're arguing that irregularities in the safekeeping hearing and the safekeeping order, the problems with it are legion. It's like, God, where to even start with it? The real focus of this part of the motion is on the fact that Mr. Allen had hired an attorney, or more specifically, Kathy had hired an attorney for him the day after he was arrested. The attorney immediately got in contact with Sheriff Lesenby and with Prosecutor Nick McClelland. They acknowledged his representation, helped him coordinate meeting with Rick in the jail on the night of the 27th, the day after his arrest, and then whisked him off to White County without having any type of a safekeeping order or hearing or notice or anything like that. So the brief is arguing that was illegal, which, probably looks like it was. And then subsequently, on the 1st of November, Mr. Allen wrote the letter to the court that appears in the court file where he asks for an attorney to be appointed to him. However, despite the letter being properly mailed, properly addressed, proper postage on it, it was returned to the White County Jail for some unknown reason, and it was remailed. It was received by the court, and it was file stamped as of November the 9th. So that's quite a few days after the safekeeping hearing. So another point that the motion is making is that this is also error because defendants who are incarcerated get the benefit of what's called the mailbox rule. The date that counts for service or filing, or basically calculating whether you've met your deadline or not, is the date that you stick something in the mailbox, not the date that it lands in the court. In the meantime, of course, couple days later, I think it's the 3rd of November, Sheriff Lesenby files his request for a safekeeping order. And the defense identifies a whole bunch of problems with this request. So, first off, he never served it on anybody. Yeah, that's a bit of a problem. It's a motion. It needs to be noticed. And as we've already mentioned, he knew that Richard Allen had an attorney. But even if he didn't know Richard Allen had an attorney, or thought the attorney was just, limited in his scope and was already done or something like that, he would still at least need to serve Richard Allen himself. And there's no record that he did that. Another problem with the safekeeping order, it's unverified, meaning that it's not under oath. There's no sworn factual basis for any of the representations that it contains. And so when a court is going to make a ruling on a motion, it needs to be based on competent evidence, sworn testimony. And there wasn't any of that. So next argument the motion makes is that, hey, there was nothing the court could have relied on to find that there was a basis for the safekeeping order to be entered. Another problem, of course, I talked about this in my Substack piece when we looked at the safekeeping statute. There's a provision that says the defendant has the right to refuse when the safekeeping order is just based on considerations of his own personal security. And there's nothing in Lesenby's affidavit that asserts a basis for the safekeeping order that's anything other than keeping Richard Allen safe. So these are all big problems. Final problem is that whole issue with Judge Diener apparently sat down and helped him do it, helped him write it. This is a problem under two different parts of the judicial ethics rules. The judges aren't supposed to be assisting anyone besides family members in preparing documents. Yeah, that's a little bit of a conflict of interest. And secondly, of course, you're not supposed to engage in ex parte communications. So a little bit of a problem on both of those, and being that those violations occurred basically Judge Diener should not then have been involved in the safekeeping hearing. He should have recused himself. So because of all of these issues, the defense is arguing he had an attorney, he had a right to an attorney because this was a critical stage in the proceeding. Critical stage is a concept that comes out of the Sixth Amendment case law, the right to counsel case law, and it just basically says, it talks about when that right attaches, because it doesn't attach typically before formal charges have commenced. That's like your Miranda rights and stuff. That's actually a Fifth Amendment issue. Your right to counsel for Miranda purposes is a Fifth Amendment issue. It's there to protect your privilege against self-incrimination. But the Sixth Amendment typically doesn't start until the criminal charge has been brought against you. Well, that was violated in this case because he had his initial appearance, he had the safekeeping order where his rights were affected, his liberty and conditions of confinement and so forth. And he didn't have an attorney, didn't have one provided to him, despite having requested one, or he did have an attorney and everybody just sort of went out of their way to ignore that fact. So it's a pretty alarming and frankly, to me, a fairly egregious set of circumstances. Now, having said that, is this going to get his conviction reversed? I'm very doubtful. And the reason why is because this is just a situation where, had all of these issues been raised at the time, I think they might have had some teeth, and I think they might have had some success in being able to, get him moved or get him brought back to Carroll County, get him held in different conditions, something like that. But the problem is that it's a very attenuated set of circumstances that led to, from the safekeeping order to him being convicted. It was a series, process of years, led him to the Westville Correctional Facility, led to his treatment there, his mistreatment, his deterioration, this whole sideshow with Dr. Walla and, whatever was going on with that. And so allegedly the confessions to her, allegedly the confessions to the other people on the unit, the phone calls to his wife, the deterioration, the Haldol, et cetera, et cetera. And so, yeah, you can say, well, it's a but-for cause, the safekeeping order. None of those things would have happened but for the safekeeping order being entered. But the problem is that it's the constitutional violation has to be a little bit more directly related to the harm that you're attempting to have remedied. And so the safekeeping order itself is fairly attenuated from the conviction. I don't think they're going to give it to him. I think they're going to say it's a little bit too remote. There's too much other stuff that happened, too many other things that factored into the state's evidence of the conviction and so forth. So while I think it's a very meritorious argument, and I think they're making a strong case that there were all kinds of legal problems with this process, I don't think he's going to get a new trial as a remedy for the safekeeping order violations. Now, one of the things that I thought was interesting about this part of the argument, it rested on United States versus Chronic, and that was a strange choice to me. Chronic is a case that involves an allegation that a defense lawyer is basically unprepared or unqualified. It was a case where a guy's attorney, he gets appointed an attorney who's a young kid. It's like his first jury trial. He was a real estate lawyer, had never done a criminal case before, but he went to trial and actually did a pretty decent job. And so Chronic, the court basically said, well, we're not going to just, overlook his performance based on, factors like, well, he was young and he didn't have a lot of experience and he didn't have a lot of time to prepare and stuff like that, because it would mean that, he could perform flawlessly and still be considered, ineffective, and that doesn't seem right. That might be a little loud, but you know, it's fun. It's ambiance. So it was just, I thought it was a little bit of a strange choice because it factually just wasn't really on point. There are other cases that involve deprivations of the right to counsel or circumventing the right to counsel that, I don't know, just intuitively I would think might be more of the cases that you would hang your hat on in this type of situation. But that being said, the point that they were getting at in Chronic is that when there's a deprivation of the right to counsel, part of the reason why you want to establish like a structural error, okay? Complete deprivation of the right to counsel is a structural error. Those are great on appeal because that's an automatic reversal. You don't have to show prejudice. A chronic error, hang on a sec, I'm going to walk past this because it's pretty loud. When I can even hear it through my headphones, I know it's going to be blaring in the mic. Oh, somebody's got some weed down here. All right, anyway, so what I was saying was that the chronic error is not a structural error like this. It's not an automatic reversal. It is a situation. So basically what that means then is that the defendant still has to show his right to a fair trial was prejudiced. What chronic does is it allows a presumption that prejudice occurred. And so that's essentially, I think, why they're using it, is to try to establish, to try to kind of get over that hurdle, that attenuation problem that I was talking about, where this is like so just kind of remote from the conviction. If you don't have to show that it had a specific effect on the outcome, then you got a lot better chance of success. The problem, though, is that presumptions can be rebutted. Presumptions can be rebutted, and that's where I think it's going to fall, because I think the attenuation problem here is what the rebuttal is going to consist of. Just basically that there's really no way to say that all of these, confessions and things like that wouldn't have still happened had he not been subject to the safekeeping order, that a lot of those other things were independent of the safekeeping order itself. Like if he had been sent to Westville, but, I don't know, gotten his tablet earlier, hadn't gotten yelled at by the other inmates, hadn't been called a baby killer and stuff like that, maybe it wouldn't have gone the way it did. So, yeah, just not really sure that one is going to fly. As strong as I think it is from a legal standpoint, it's just a situation where I don't think there's really a remedy that they can give to him at this point. The time for the remedy on safekeeping was back at the time that it was going on. So then the second issue that was raised is the NAPUI issue. NAPUI versus Illinois. This is a case, the United States Supreme Court case that says that it's a violation of due process for a prosecutor to knowingly present false evidence and to obtain a conviction on the basis of knowingly false evidence. And the basis for this is the Brad Weber ban. The defense has gone back through the discovery, some of the discovery in the case, and among the things that they found are some surveillance video. It looks like it's from a neighbor's house, and it shows the county road that leads down to Brad Weber's driveway and Brad Weber's driveway itself. And so, according to these videos, you could see Brad Weber's van arriving home, and the timestamp on the video is 2:44 p.m. Now, you probably remember, Libby's phone stopped moving 2:32 p.m. It was a really critical time in the state's theory because that's the time, according to them, that the girls are dead. The phone stops moving, it never moves again. And so for the white van to have interrupted Richard Allen so as to corroborate what he told Dr. Walla about how the crime supposedly took place, it needed, to go by sometime before 2:32 p.m. because he would have had to have gotten scared and then led the girls across the river and then murdered them and so forth. So, very least, like a few minutes before 2:32. So 2:44, of course, well outside that time frame. The other thing that the defense had buried in the discovery was cell site location information for Brad Weber, and it showed his phone pings at home at 2:50 and then just pings around the property continuously until 11:55 that night. So first ping at 2:50 in the afternoon. Again, it kind of corroborates that time frame of the car arriving home, but falls well outside when it needs to be for it to fit the state's theory. So the defense is arguing that the prosecutor had all this information, therefore the prosecutor knew that Brad Weber's testimony was false. And so because of that, again, new trial should be ordered. This one is where I think it gets tough and it gets tricky. And the reason why is this. The defense had this stuff. And unfortunately, that means it's not newly discovered evidence. It doesn't matter if they didn't understand the significance. It doesn't matter if it came up, late in the day in the trial with Brad Weber's testimony and the time frame and everything. The defense already had it, so it's not newly discovered. As far as NAPUI error, I don't think that that's going to be accepted. And so let's talk about NAPUI itself, because I think it's important context about what it means to actually present knowingly false testimony. You've probably heard me, and I'm sure some other people, talk before about, what lawyers actually know versus what you might think or what you might believe or what you might just defer having an opinion on because there's conflicting evidence and so forth. These are all some pretty fine distinctions. And so NAPUI itself was a case where a prosecutor puts his informant on the stand, informant testifies, prosecutor asks the informant, have I promised you any kind of benefit in exchange for your testimony? The informant says no, and that's a lie. And the prosecutor knows it's a lie because the prosecutor is the one who made him the promise. And so there's no real wiggle room in that one for the prosecutor to not have personal knowledge that what that witness was testifying to was false. So it's a pretty extreme circumstance in NAPUI, and that's why ultimately I think this issue is going to fail too, at least at this stage and in this proceeding. And the reason why is because the evidence is conflicting. And so if the evidence is conflicting, the prosecutor doesn't know. There could be reasons why Brad Weber's van didn't ping. They could, argue that the timestamp, the timestamp hasn't been validated. I didn't see anything in the defense motion that authenticates the timestamps on any of the video. So maybe they never did that. They don't know if the times are correct. So, ways to get out of the argument that they would have actual knowledge. And so this is where the appellate work gets not very fun, because unfortunately it means that if they're going to get anywhere with this argument in the appeal context, they're almost certainly going to have to do it through the framework of ineffective assistance of counsel. They aren't going to be able to argue it's newly discovered. The defense had it, but the defense didn't use it. And so the question becomes, why didn't the defense use it? If there's a strategic reason for why the defense didn't use it, then that's not ineffective. But if the defense was just so overworked and so burdened and forgot it was there or didn't see it or anything like that, that's not gonna cut it. It's not a strategic reason. And so I think that's going to be the strongest basis for them to be able to present this error, is to say, look, defense counsel messed up. They should have raised this at trial. And that's where chronic, I think, becomes relevant and sets a little bit of the tone of what the standard is in the case. Because chronic does talk about, these are some of the factors that go into whether counsel is effective or not. Your level of experience, certainly, but also your time for preparation, your attention to the case, and things like that. So I think that might be where it's heading, which is really unfortunate, but it's just kind of one of the inevitable parts of the criminal justice process, really. Everybody makes mistakes. To err is human, and nobody is perfect. You try not to take it personally. At least I think most of the good lawyers don't, because we know we're not perfect. I've certainly made mistakes. There have been situations where, they've had consequences, and so I've owned up to them and done everything I could to get them remedied. I'll tell you a quick story about that. I had a guilty plea for a juvenile client that I was ready to put through. We're, they're in the courtroom ready for it, and comes to my attention, there's going to be an immigration problem. The client's status might have a little bit of a problem with this particular crime that he's about to plead guilty to. So I put the brakes on, and I told the prosecutor, we're gonna have to hold this one up. We gotta figure this out a little bit further. Well, prosecutor gives me all these assurances, swears up and down, had all these conversations with ICE. They don't do anything with juveniles. They're not gonna go deport a juvenile. So I'm like, all right, with that assurance, we'll go ahead and we'll go through with the plea deal. So we go through with the plea deal, and the moment my client is let out of juvenile detention, ICE is right there to pick him up. Next thing we know, he's in a detention facility in Tacoma. Next thing we know after that, he's in a detention facility down in San Francisco. I went to the judge and I said, hey, I fucked up. It's absolutely completely unreasonable of me to just rely on what the prosecutor said in this plea hearing. No reasonable attorney would have done that. I knew in my gut this is a problem. I knew that the charge was it was a removable offense, and so really no excuse for doing that. Judge said, yeah, all right, we'll withdraw his plea. So they did. And we were able to get him back in court and ultimately get him some relief. So it happens sometimes, guys. It's just part of the nature of the beast. But it isn't fun. It's not fun for the appellate attorneys to have to make the argument. It's certainly not fun for the trial attorneys, who are the subjects of it. But I think that's where it's going to have to go. I think it's going to have to be an argument that trial counsel was ineffective for not presenting this evidence at trial after Brad Weber testified, because it would have potentially changed the weight that the jury would give to that whole story about the white van and the significance in Richard Allen's supposed confession and so forth. Wow, there's a whole carnival thing going on here. Share that with you guys. I hope this isn't too loud. I might have to walk back and maybe do this over. I am approaching the Carretera Austral here. This is the main highway that goes down into Patagonia, northern Patagonia. It starts at Puerto Montt and it runs down to Via O'Higgins, somewhere in the ballpark of 2,500, 3,000 kilometers. I mean, it's a long road. When I came down here last year, my cousin and I drove it down to Via Cerro Castillo, and I think we probably took 10 days maybe to go that far. It's long. I mean, that's probably 2/3 of the way down, maybe. It's a really long highway. All right, I'm going to turn around here. So now I'm going to walk into the sun. Well, guys, so that's kind of my thought about the second issue. It's unfortunate. I think it's strong, but I think they're going to have to cast it as ineffective assistance on appeal. Third issue. that was raised. Similar issue. Ron Logan confessed. Ron Logan confessed again. Okay, we already knew that Ron Logan confessed. He had confessed to, allegedly confessed to a jailhouse informant named James Haas, who had written a letter, handwritten thing with some allegations in it about, what Ron Logan had said while they were cellmates together. This is another one from a guy named Ricky Davis, also a cellmate of Ron Logan, but this one took place in May of 2017, so we're talking just a few months after the girls had been murdered, when Ron Logan was back in custody on the probation violation. And unlike the James Haas stuff, this confession has got some details in it, and some of those details, you want to talk about stuff only the killer would know. Yeah, cutting the neck and hitting the artery on the oldest one. That was definitely a detail. That was very much a detail at trial. It was very specific. Libby's throat was cut, hit an artery. She bled out very quickly. Abby, throat was also cut, but not an artery, just the jugular veins. So she bled out much more slowly. Ron Logan also supposedly reports that he had killed the oldest one first and then took the youngest one away for a little bit, and but he didn't say where. And so that's a potential explanation for why Abby's blood was not really at the scene. Really not a whole lot there, just a little bit of seepage around the back of her neck, pretty equivalent to the amount of seepage that was there at the back of Libby's neck. But Libby, of course, had also bled, copious amounts in other parts of the crime scene. So, pretty detailed confession. And confessions like this, they can be admissible evidence under the hearsay rules. Ron Logan is dead, of course, so they're not going to call him in to testify. He can't, so it is technically hearsay. It's an out-of-court statement made to somebody that's being offered for the truth of the matter asserted. But it's a hearsay exception under Rule 804 because it is a statement against interest. It is the kind of thing that nobody would say. It so tends to make you look bad that, like, why would you say that if it wasn't true? It doesn't help you to say it, it hurts you to say it. And that's the typical justification for admitting, most defendants' confessions and statements against interest and things like that as well. So, yeah, this one, the defense is kind of arguing creatively, I think, that it constitutes newly discovered evidence because even though they had it, this was in the Orion database. This was a tip in the Orion database. So the state certainly had it, but they'd also turned it over in discovery. Defense argument is that because one of the details in Ron Logan's confession was that he used a box cutter, that they would not have known was a significant fact until after the medical examiner testified and had his, eureka moment, I think they called it in the memo, his eureka moment in the garage, in the workshop, where up to that point for years he'd maintained that the wounds on the girls had been caused by two separate weapons. But then he suddenly saw a box cutter and realized, no, I think it could have been that all of the wounds had been caused by a box cutter. Well, Ron Logan said that he used a box cutter. And of course that he cut the oldest girl's neck and severed an artery, which is true. So, basically, that's the argument. newly discovered because the fact of its importance wasn't known until it came out kind of by surprise at trial. It's a very clever and creative argument. Again, I don't think it's going to get them there because they still had it. The whole point of newly discovered evidence is that if you couldn't have used it at trial, if you didn't have access to it, then they can't hold that against you. You know, that wouldn't be fair. But the problem here is they did have it. And so even if they were surprised by that fact, it was in their war chest. You know, they could have whipped that out. Now, this is a little bit confounded by the fact that Ron Logan, as a third-party culprit, he'd been specifically excluded by Judge Gohl. So wasn't supposed to be even mentioned at trial under that motion in limine that the state filed. However, it would not have prevented the state or prevented the defense from having one of the sidebars or something like that and asking the court to revisit that order in light of the testimony that the medical examiner had just given, where he said it was a box cutter, and these other details that are there in Ron Logan's confession, that therefore there's a nexus. Now, would Judge Gohl have allowed it? Of course, $1 million question. I tend to think probably not, because I'm not sure anything constitutes a nexus in her court. But at least then they would be in that same context on appeal of just arguing, hey, she got that ruling wrong. The defense tried, and you just need to look at the legal basis for the ruling and see if it's justified or not. I would tend to think a confession that goes to rebutting the kind of key element of the state's case, that Richard Allen had these facts that only the killer would know. You know, Ron Logan seemed to have some facts that only the killer would know. So might make it a little more likely that Ron Logan is the perpetrator under the state's own reasoning in the case. So once again, because they had it, didn't use it, I think this is one that's going to have to come up through ineffective assistance of counsel. You're just going to have to argue no strategic reason not to bring it up, no strategic reason not to ask the court to revisit the ruling in limine excluding Ron Logan as a third-party suspect, no reason not to put it in the record as a proffer so that the appellate court could take a look at that. It's unfortunate, but as ineffective assistance arguments goes, I do think it's a pretty strong one. So then the last issue that came up in the motion was a supplemental affidavit from Stacey Eldridge. She was the defense's digital forensics expert. And she just basically submitted an affidavit that said that no, dirt and water would not cause an iPhone to register a headphone plugged in, a wired headphone plugged in, and then a wired headphone pulled out. So this one, I think, you have a better argument that it is newly discovered evidence because, Cecil did his Google search out there in the hallway. That wasn't anticipated. They didn't know he was going to try to come up with that type of statement, that type of argument. So, yeah, okay, it's newly discovered. But I think the question on this one is, is it realistically going to tip the scale in the case, that fact alone? I mean, it's hard for me to gauge all this just because I didn't see the case getting anywhere near beyond a reasonable doubt, even without all this other stuff. And so, yes, the fact that under the state's theory, the phone was supposed to be, undisturbed under the bodies of the girls from 2:32 on. The fact that headphones were plugged in and plugged out, and that would not register, as the state argued, just because some water or dirt or something like that got into the jack. And she also points out there's no evidence in any of the examinations of the phone that there was any type of water damage to the phone or any type of like detritus on the phone. Nothing like that. So pretty good argument for newly discovered evidence. But in this particular case, I'm not sure the court's going to find that fact in and of itself is going to tip the scale, because they're going to look at the totality of it and they're going to say, well, it's a disputed fact at best, and there's no guarantee that the jury is going to buy it, and the jury could have just as much relied on, Richard Allen's statements, put himself on the bridge, so on and so forth, all the arguments that we already know for why folks say Richard Allen is the perpetrator. So that's kind of my bottom line on this motion, guys. 4 issues. I think they're all good issues. This is part of the frustrating thing about appellate work. They're all good issues. I just don't think any of them are going to get Rick a new trial. Not at this stage. And I think their best bet at getting Rick a new trial is if on appeal they present those 2 issues about Brad Weber and about Ron Logan's confession, and they pitch him through the ineffective assistance of counsel lens. Sucks, man, but that's just part of the deal of being a defense lawyer. The shit flows downhill, as they say, and the court, if they can find a way to make it your fault, the defense lawyer's fault, as opposed to, the prosecutor's fault, the judge's fault. Sometimes they'll take that. They'll jump on that. It's the path of least resistance. So, sad to say, I think it's in Rick's best interest for them to have to do that, because obviously I think the attorneys just put a massive amount of work and a massive amount of themselves, their effort, their lives, everything. I mean, honestly, a trial like this probably takes some time off your lifespan. And so it sucks that that's your payback, but that's just kind of part of the deal. Kind of part of the deal with this job. And ultimately, if it got him the result that they want, the new trial, most lawyers wouldn't mind. I think they'd be just fine with it. I'm gonna get past this guy again. Nice salsa vibe on this one. So as you can see, it's still a beautiful evening out here. All kinds of people still out. Chileans tend to eat late, stay up late, get up late. I was commenting to Heidi, my friend Heidi and Marlene, when they were here, that the earliest, the super crazy early bird grocery store might open at 8 o'clock. The normal time of things opening is probably 9, but 10 is really not unusual. People don't really get started early here. We're like the kind of folks, we're sleeping on the ground and stuff, so you pack up your campsite and kind of get moving pretty early, especially because down in Patagonia, the weather pattern is that the mornings are beautiful. It's still, it's sunny, it's really the nicest part of the day, it's cool. And as the day goes on, the wind comes up. If there's going to be clouds and rain and stuff like that, that typically comes in the afternoon. If it's going to get real hot, that typically, starts 3, 4 in the afternoon. So we're going to be doing hard hiking. We want to get it done. But we will be the only people on the trail for a couple hours. So just kind of interesting. Different cultures and stuff like that, and different tolerances people have for different conditions. I'm a little gringa for the climate down here, but it's all good. All right, guys. Well, I'm out of the music zone now, so I'm gonna go ahead and wrap this up. Hopefully, this has been a little bit of a helpful take as far as my predictions for what's going to happen with this motion. And I do really want to give kudos to them for filing it and for making that record, because ultimately I think these guys aren't idiots. I think they know that probably what they're doing is making the record to be able to make that ineffective assistance claim. And so it takes a lot of integrity to do something like that. And I think it's worth recognizing, that they stepped up and did it. And the other thing I want to mention too, because I had some pretty serious concerns about this local rule in Carroll County where they automatically withdraw the attorney after the judgment and sentence. And they do that even though the defense has a right to present, this kind of motion that they're presenting here, this post-judgment motion before the appeal process starts. And so that was a little bit alarming to me. I understand why you have a rule like that. It can be inefficient to expect the lawyers to file something withdrawing themselves, when they're done with their representation, because a lot of attorneys just won't do it, or they'll forget to do it, or whatever. And so then, your record keeping is all messed up. And if there's one thing the court doesn't like, it's when its papers are untidy. Want everything tied up nice and neat and resolved with no loose ends. So that's, I'm sure, the reason for the rule is just for administrative convenience. But it concerns me because it makes me wonder, okay, they filed a limited notice of appearance to be able to file this motion, but they weren't reappointed. Are they going to get paid for this? I mean, I got to think they are, but I also got to wonder if they're going to have to fight about that, just given the problems that they documented already about the difficulty that they had getting paid for things that they were clearly entitled to be paid for. So that does alarm me, and it's just one more point that I wanted to bring up, because again, it speaks to the integrity of what they're doing to try to make this record to benefit their client, put him in the best possible position he can be for appeal. They may not even get paid for it, and they may be putting themselves in the line of fire from, the appellate folks like me who've got to look at it from all angles and decide what's going to be the best way that these facts can be leveraged to get him the best possible outcome. So, hope you enjoyed this take and this little walk with me on the streets of Chile. I'll listen back to it, and hopefully it's not going to be too intolerable to listen to with all of the noise, but just wanted to give you guys a little bit of the flavor of this little city down here. Fun little place, Puerto Montt, and a little touch of summer as well. I gotta tell you, I'm really enjoying this. But it's not going to last. I am going to be flying out tomorrow. I fly down to Punta Arenas, which is much further south. It's probably mostly known as being the jumping off point to Torres del Paine, which is one of the natural wonders of the world, one of the big national parks down here in Chile. But that is not where I'm going. I'm actually just in Punta Arenas for about a day, and then I get on another plane to go down to Puerto Williams, which is the southernmost city on the earth. It's on Navarino Island. And I think I'm going to be doing a live stream from there because Puerto Williams has about 4 streets. Not going to be a lot to do. I'm going to have some time to kill. I got about a day to kill. I'm going on a hiking trek down there for about 4 or 5 days, so I'll be back off the grid again when I go. But I'm not going to want to, be walking around and stuff like that before I head out a whole lot, because I'm going to want to kind of save my legs and my feet and stuff for this trek. So look forward to a live stream from the southernmost city on the planet, probably Friday or Saturday. Haven't quite sorted out yet what it's going to look like timing-wise. But we'll be watching the Koberger motion to suppress hearing. Yeah. I've been hearing an awful lot about it, seeing a lot of commentary about it on Twitter, seeing like little tiny bits and pieces of takes and stuff like that, but have not taken in the full thing myself. So we're gonna do it cold, guys. You're gonna see me react as this goes down. So it looks like there's been a lot of new information that came out, and yeah, I'll tell you what I think about it. I don't quite know yet if it's you know, really favorable to Mr. Kohberger or unfavorable to him. Sounds like it might be a little bit of a mix of both, but we'll watch it together and we'll see. So with that, guys, I'm going to go ahead and sign out. Hope you enjoyed this little walk with me, and I will talk to you guys soon.